For today's story, we are dealing with a new filing in the Vallow Daybell lawsuit, dealing with a motion to remand the indictment to the grand jury for further proceedings. Now, I have to be honest, I've never even heard of such a thing being done before. So this is interesting. So the grand jury gave some criminal charges, and they've delivered that, and now the case is ongoing, with trial supposed to begin in January, incidentally. And we'd like to send the case back to the grand jury for further proceedings, which would cause delays of the trial, significant delays of the trial, if granted. So I've never heard of this happening before. I mean, I've heard of cases getting dismissed by the trial court, often without prejudice, because there's some deficiency in the grand jury, but I've never heard of a case being remanded to the grand jury. So, okay, let's read this and see what's going on. All right, so Daybell, by and through her attorneys, hereby requests the court remand the indictment to the grand jury for further proceedings. As currently worded, count 1 and count 3 of the indictment will be confusing to the trial jury, and the crimes as currently stated do not meet the elements of a single crime, but in fact lump 2 crimes into one allegation, making it a general felony for possible punishment purposes of sentencing. Okay. Defendant has been charged with conspiracy to commit first-degree murder and grand theft by deception in counts 1 and 3 in the indictment. The defendant sees each of these 2 separate allegations and 2 separate acts which, if proven, cause 2 separate crimes. They would be separate crimes, at least on their own face. Yes, that's why they're in different counts. The allegations allege the single crime of conspiracy to commit first-degree murder and grand theft by deception. So we're saying that the allegation itself says this is 1 crime, even where they're being charged as 2 crimes. The allegations allege the single crime. It references 5 separate statutes. These do not overlap in elements. To lump first-degree murder and grand theft by deception into 1 charge is contrary by statutory construction, contrary to Idaho criminal rule, as well as being confusing to the jury to try and navigate the elements. Well, there were 2 counts, and so the grand jury presumably returned a true bill on both counts. So I'm not exactly sure where the point of the confusion is coming, where these things being combined. It's unclear as to whether or not the grand jury properly found that each element of count 1 and count 3 of the indictment was valid, as grand jury deliberation is secret, and no one but the grand juries themselves know if the elements satisfy the criminal rule, which states that there may be 2 or more separate charges in a grand jury indictment, but each must be voted on separately by the grand jury. So the grand jury just returned one thing that contained both, so we're not sure which they found, so there's a defect that way. That's interesting if true. Furthermore, there's no statutory punishment for this allegation. I mean, as phrased, if that's what they did. While the statutory punishment for conspiracy to commit first-degree murder and the separate and distinct punishments for grand theft by deception, there's no statutory punishment for that combination. All right. Idaho Code states that an indictment must contain a statement of the acts of the offense in such a manner as to enable a person of common understanding what is intended. The Idaho Code states the indictment must be direct and certain as it regards the offense charge and particular circumstances of offense charge when necessary to constitute complete offense. The elements of conspiracy to commit first-degree murder and grand theft by deception combine 2 separate and distinct crimes into 1, or in the alternative, the grand jury may be alleging conspiracy to commit grand theft by deception and a separate crime of conspiracy to commit first-degree murder. The Idaho Code states that when 2 or more offenses may be charged in the same indictment, they must be charged as separate counts. But that sounds like that happened with counts 1 and 3. Is it the way the grand jury returned its decision? Is that the nature of the problem? They returned it as a combination? The defense is unclear if the grand jury is alleging a conspiracy to commit grand theft by deception while in the commission of first-degree murder. If that's the case, the defendant would ask the court to strike first-degree murder language, as is not an element of the crime of grand theft, and vice versa. If in the alternative, the indictment contemplates a conspiracy to commit first-degree murder, and while doing so also committed grand theft, those crimes are separate and distinct and would need to be separated into 2 separate and distinct charges. It is unclear to the defendant as to what the grand jury is alleging. If the defense cannot figure out the charges, it's highly unlikely the trial court will either. Okay, so we're saying the grand jury screwed it up because they were charged with count 1 and count 3, but we're saying the grand jury, when they actually return the indictment, returned it as a commendation. And we're not sure what they actually found as a result, because we're not clear what the charge is. While Idaho Code and Idaho Criminal Rule allows for amendment to indictment, it's unclear how this would play out should the court not remand the indictment for further proceedings. It seems to conflict with the Fifth Amendment to the U.S. Constitution. The general rule is indictments cannot be amended in substance. An amendment to an indictment occurs when the charging terms of the indictment are altered. This follows the fundamental distinction between an information and an indictment, which apparently, at least in this case and this circumstance, must be returned by a grand jury. If indictment could be changed by the court or the prosecutor, then it no longer would be an indictment. So to the extent that Idaho law requires this to be done by indictment, which apparently it does, then the prosecutor can't fix it. Indeed, in Russell versus United States, the court pointed out that a consequence of amending the indictment is the defendant could then be convicted on the basis of facts not found by, and perhaps not even presented to, the grand jury which indicted him. The Fifth Amendment forbids amendment of indictment by the court, whether actual or constructive. Okay. The United States Supreme Court, reviewing the history of grand juries, quotes Lord Mansfield on the subject. There's a great difference between amending indictments and amending information. So in some states, you simply charge by information. The prosecutor just files it. That's called an information. An information is where the prosecutor just files it. They don't go to a grand jury. An indictment comes from a grand jury. Some states allow information. Some states require indictments as to some kinds of charges. Okay. Indictments are found upon oath of a jury, the grand jury, and ought to be only amended by themselves, but information are as declarations in a king's suit. Basically, an officer of the court has the right to frame them originally. He may, with leave, amend them in a like manner, as any plaintiff can. Right. If you can just file them, you can just amend them within the bounds of rules, but if it has to be done by a grand jury, you don't have power. In one case, the defendant was convicted of unlawful interference with interstate commerce in violation of the Hobbs Act. So Hobbs Act is an act that makes robberies federal. The indictment charged that the victim's contract was to supply ready-mix concrete from his Pennsylvania plant to be used in the erection of a steel mill in Allenport, Pennsylvania. Performance on the contract involved, according to the indictment, shipment of sand from various points in the United States to the victim's ready-mix concrete plant. The trial court permitted the government to offer evidence of the effects upon interstate commerce, not only of the sand being brought into Pennsylvania, but also on the interstate shipment of steel from the steel mill to be constructed for the ready mill concrete. The United States Supreme Court reversed the defendant's conviction on the ground that he was convicted of a different crime than the one charged. The grand jury, which found the indictment was satisfied to charge conduct interfered with interstate importation of sand. But neither this nor any other court can know the grand jury would have been willing to charge conduct that would interfere with interstate exportation of steel from a mill to be built with the concrete. Although the trial court did not permit a formal amendment of the indictment, the effect was the same. If this court would rather strike the language of either first-degree murder charge or the grand theft by deception in each count, the defendant would not object. An amendment for the existing of surplusage that has the effect of narrowing a defendant's liability without changing the meaning of the charge that is presented to the grand jury is permissible. In United States v. Whitman, this court held it was proper for the government to strike the references to overvaluation of property, alleging false statements to a federally insured bank. A similar deletion was approved by United States v. Ramirez, even though defendant's theory of defense was thereby altered. Lastly, should the court not choose to remand the indictment or strike the language in the allegations, defendant would ask the court to make a ruling which would be consistent with Idaho Code as to punishment, and the charges for count 1 and count 3 be declared punishable pursuant to law as a felony not otherwise prescribed in the code, and the punishment shall be a maximum punishment in imprisonment for not more than 5 years. I love it. I love it. So because of the way this is being charged, we want to convert this now combined charge. That's what we're alleging, right? We're not being charged with first-degree murder and also being charged with this other crime. We're being charged with first-degree murder and that, which is one crime. And since it's not otherwise specified, the maximum possible imprisonment would be 5 years as a felony not otherwise provided by code. That's pretty hilarious. For these reasons, and in the interest of justice, defendant respectfully requests the indictment be returned to the grand jury for further proceedings consistent with severance of charges, or in the alternative, the court strike language is either grand theft or first-degree murder in each count. That's pretty awesome. That's pretty awesome. So, I mean, I don't know enough about the eccentricities of Idaho-specific law to be able to comment about this, and I'd also have to go back and read the actual underlying indictment and see exactly how it's written. But this is some pretty good stuff right here. I don't know whether or not they're right or not. I don't know whether or not they're just like playing games or not, but it's a very interesting thing. So who knows? Maybe this trial will get delayed to dates beyond. Well, at least for a moment, that brings us to the end of discussion of this case.